So thank you everyone for attending. This is our third presentation now in a series of presentations made by the Sexual Assault Response Team in Dakota County. So today we'll be hearing from Alina Stevenson from Legal Assistance, and I'm just gonna let her take it away. If you aren't able to attend any of our trainings in the SART series for the month of April, they're all going to be recorded, and we'll be able to send them out at the end after all the presentations are done. So thank you, Alina, for being here, and go ahead.
Thank you. Yeah, my name is Alina Stevenson, and I'm a staff attorney at Legal Assistance of Dakota County. We are a nonprofit legal aid organization, and I'm also here as part of the Dakota County SART team. And the Dakota County SART team is a group of individuals who are working to coordinate a collaborative, multidisciplinary response to sexual violence that promotes victim and survivor healing and well-being. I did hear just a couple of people joining. Do we want to give it just another minute? I can wait until 1:05.
Yeah, I think we're okay to just keep going. I know there's lots of 360 employees that are probably at another training today, so that's going on at the same time. So they'll probably be looking forward to the recording. So I think you're good.
Okay, sounds good.
Yeah.
So the SART team has members from different organizations that work with survivors of sexual violence. We have members who are police officers, prosecutor, a forensic nurse, as well as myself. I'm a civil legal attorney, and then also some community advocates as well. So it's a good group of people to be able to work together and think collaboratively about how we can make the process for sexual violence survivors to be as non-re-traumatizing as possible. The Legal Assistance of Dakota County team is a relatively small team. We have 3 attorneys on staff, our executive director, Sharon Jones. We have a brand new volunteer coordinator who doesn't take cases, but helps us place cases with attorneys in the community. And then myself, I'm a staff attorney, and my role is to take cases that we can't place with a volunteer, or to take cases that need immediate attorney assistance that can't wait for a volunteer to be able to take their case. We also have some amazing support staff. If you were to call our office, Genesis is likely the person who you'd speak to on the phone. She's our legal assistant. She works full-time. Then we also have an intake specialist, Mocha, who works part-time and does all of our intakes for us. Not on the screen is also we work with law students quite often. And so we have law students help us with some of our drafting and also help them get some in-court experience. So it's a win-win for us and the law students. Our mission, this isn't our official mission. It's the mission that I kind of created for us after working here and seeing how we work with our clients. And it's to provide a victim-centered advocacy in civil legal cases. We want our clients to feel heard and be able to have agency during the civil legal process. And so what are some civil legal remedies? So the civil legal remedies that LADC focuses on are providing legal advice and representation in orders for protection, harassment restraining orders, custody, and divorce cases. And all 4 of these areas of law can be remedies for survivors of sexual violence. And later in the presentation, I'll dig into each of these just a little bit more so everyone will have an understanding of each area of law. And why would a victim or a survivor choose a civil legal remedy over a criminal conviction in their case? There are lots of reasons. The first one is that it can be more victim-centered. If a survivor wants to not have contact with their perpetrator and they are going through the criminal justice system, it has to go to a police officer and has to report it to the prosecution. The prosecution then decides if they're going to charge, and only after someone is charged would a no contact order be in place. In the civil side of things, if a victim wants to not have contact with the perpetrator, they can fill out a petition, file that petition, and the court can grant an ex parte restraining order within 24 hours. And so it's much more immediate, and the victim gets to choose that action. Sometimes when you're going through a criminal case, the prosecutor chooses to have a no contact order when the victim doesn't even want that, because for some reason that could hurt, their childcare or funds for something. And so it's just being able to have the autonomy to make the decision about the relief you want is one of the really good things about the civil legal system compared to the criminal justice system. The other reality is that not every case is appropriate for the criminal justice system. Again, the prosecutor gets to decide whether or not a case is going to be charged. And a lot of the cases aren't good cases to be charged. Prosecution has to think of a lot of outcomes when they charge a case, and so it might not be a good fit for the criminal justice system. The other nice thing about civil law as opposed to criminal law is that there's a lower standard of proof for civil cases. So a lot of people know beyond a reasonable doubt is the standard of proof for a criminal case, which means that it's a pretty high standard. You have to convince someone that beyond a reasonable doubt that it happened in the way the prosecution is saying it happened. In a civil case, it's a preponderance of the evidence, which is a much lower standard. A lot of people don't like to put percentages, but if you were going to put a percentage on a preponderance of evidence, a lot of people who do put percentages would say it's a 51-49 of convincing a judge that the events that are alleged in the petition happened, versus some people would say in a criminal case, it's more of a 90% 10. So you have to convince a judge or a jury to 90% that the events alleged happened in the way that they said they happened. So those are some of the reasons why a victim would choose a civil legal remedy as opposed to a criminal remedy. Another reason would be that some of the remedies, such as custody, parenting time, a divorce, are things that a victim can't access through a criminal justice system. They have to go through the civil system to be able to access those remedies. How to access LADC services. So we have some limitations on who we can serve. We only serve individuals whose case is being heard in Dakota County. So if someone lives in Dakota County, but they have a civil case that's ongoing in another county, we would refer out to another legal aid organization that would be able to handle that case in the county where the civil case is based in. We work closely with the 360 community advocates, especially on orders for protection and harassment restraining orders. In fact, generally only take cases once a case already has a hearing, which means that for order for protections, we ask if someone calls in and says, I want an order for protection, we say, we recommend that you contact 360's communities and talk to one of their community advocates so they can help you draft an order for protection. And then once it's drafted and been filed with the court, if a hearing is required, contact us as soon as you have a hearing date. And so that's one of the really great community partners that we have is 360 communities. For custody and divorce, the process is a little different. People can either do an intake on our website, or they can call and ask for an intake, and we'll have our intake specialist call them to process the divorce or custody intake. We are a legal aid organization, which means that we do have income guidelines for the clients that we're able to serve. Right now, our income guideline is 150% of the poverty guidelines. And if they're over income, we will refer them to a private attorney. Generally, we refer clients to attorneys who volunteer with us. And so we know they're good attorneys. They're people that we work with on a fairly regular basis. And we can vouch for them. If someone qualifies financially for our services and has a legal need that we cover, we cannot guarantee representation for them. We will always try and have an attorney call and give them legal advice so that they can know the process and have some understanding of what's happening in their case and how to proceed in their case. But we can't guarantee an attorney because we are a very small staff and have limited resources. So talking about some of our limitations, we've already talked about them a little bit. We have a small staff and we can't reach and provide legal services to everyone who requests them. It's just not possible for us. We rely on a strong volunteer network, but sometimes our volunteers get overwhelmed with their own cases. Almost all of our volunteers are small or solo practitioners here in Dakota County. And when they take a case from us, they're taking away time and space for a case that could be paying them for their work. And so we very cherish our volunteers and understand that we can't overwhelm them with our cases. And then we can only assist low income, low asset clients, which can be a barrier because there are people who are over 150% of the poverty line who can't afford an attorney. And so I name that as one of our limitations. And then one of the other things that I'll talk about a little bit more later is that we must work within the constraints of the law. And sometimes the constraints of the law don't align with the remedies that our clients would like it to. And so part of our job as advocates for our clients is centering them and their wants and needs, but also helping manage their expectations as to what they can achieve through the civil system. We work with a lot of community partners. One of the really great benefits of being a civil attorney is that we can practice in a very victim-centered way. And so I would never reach out to a community partner unless my client wants me to. So it's always a conversation with the client of, this is what I'm hearing from you. How do you want me to do this? These are some resources that I can think of that would help you. Would you like me to reach out to them? We're in contact with the police on a fairly regular basis, either providing updates to the police on what's going on with the civil case, asking them to testify at a hearing, and the police asking them for more information about how their investigation is going. So we have relationship with the police in Dakota County. We also work with medical professionals. We have our clients sign release of information so we can get access to their medical records if necessary and if our clients want us to have that access. If our clients want to be able to present a medical report at a hearing, we would have to subpoena the medical professional to be able to testify about that report. And so that's part of the relationship that we build with medical professionals. Especially if the victim is a victim of child sexual violence, we'll contact schools and child protection if our clients want us to. We do work with child protection on a fairly regular basis. If child protection is involved and a court case is started, the court case kind of takes precedent over any other civil cases involving those children. But a lot of times they'll hand them off saying, we need an order for this in the custody case. Can you help them with that? Or if we are working with a case and we think that child protection needs to be involved, we can call them for our clients and have conversations with the child protection social workers. Again, we also work with mental health providers. We get releases of information so we can talk directly to our client's therapist and kind of get some insight onto how the therapy is going, or if there's any important information the therapist needs to give directly to the attorney, just so that our clients are getting the best services possible and we're able to work collaboratively for their best outcome. Another organization that we reach out to quite often is called Standpoint. It's a statewide nonprofit that provides advice and assistance to survivors as well as their attorneys while they're going through civil cases. And so it's a resource that attorneys can use, as well as clients or advocates or someone who just wants some advice on how to handle a situation that involves domestic violence or sexual violence. So at this point, my understanding is that everyone who is on this call is someone who is working with sexual violence survivors at some level. And so I wanted to provide a kind of general understanding of what the remedies available in the civil court are and what we do when working with these survivors. So I'll just do a brief overview of orders for protections and harassment restraining orders. They have different requirements for filing for them. So it's just good to have that general understanding. So for an order for protection, it's relationship based, which means that the petitioner, who's generally the victim who needs protection, needs to have some sort of relationship with the respondent. And that can be a family or household member, having a long-term sexual relationship, having a child together, just some sort of familiar relationship. There have to be allegations of either physical harm, infliction of fear of physical harm, or criminal sexual misconduct. One of the nice things about orders for protection is they offer a wide variety of relief. You can get a no contact order, no contact with the home of the petitioner, no contact with the workplace, but you can also get child-based relief. So you could get temporary custody, temporary parenting time schedule. You can get financial-based relief, so temporary child support, or even temporary spousal maintenance if the parties are married. You can request domestic abuse programming or chemical or psychological evaluations. So that's one of the nice things about the orders for protection is they can get a temporary order in place to allow, if there's a marriage or a child, to allow things to kind of flow with a court order and hopefully create some sort of normalcy for a while until things can be handled on a permanent basis, which generally takes longer. And there's never a filing fee for an order for protection. A harassment restraining order, there's no relationship that's required for a harassment restraining order. There just have to be allegations of harassment, physical or sexual assault, or repeated unwanted acts, words, or gestures. The relief that's available for a harassment restraining order is limited. It's basically no contact with the person, their home, or their workplace. And there is a filing fee, but you can get an exemption for the filing fee if there are allegations of physical assault or stalking that reach the level of the criminal statute. One thing to keep in mind is with the order for protection, there is a provision that if it issues after a hearing, that the respondent must surrender any firearms. So that could be helpful if someone is worried, doesn't want to go through the criminal process, but is worried about someone having guns on them and making the situation more dangerous. And one of the other common misperceptions that I've heard from a lot of people is I've gone through the criminal system. There's a no contact order in place through the criminal justice system. They say either I don't need or I can't also have a civil restraining order. And that's incorrect. They're two separate areas of law. And just because someone has a no contact order resulting from a criminal case doesn't mean they can't also have a civil restraining order. In fact, I generally recommend that someone has a,
you were kind enough to verify with me that my grand.
I generally recommend that someone who has a no contact order resulting from a criminal case also get an order for protection. Just because with an order for protection or an HRO, you know the end date. It's going to be set for generally 2 years. The victim can control when it ends and can control when they get it instead of like a no contact order resulting out of a criminal case. And it's just an added layer of security. And so that's one of those common misconceptions that I like to clear up, is that victims can have both if they want both, but they're not required to. So when filing an order for protection or HRO, the petition is really important. It's really important for a couple of reasons. The first being that the court can make an initial ex parte, which means one-sided determination based on what's written in the petition. And the second is that if there is a hearing, the petitioner can only talk about events that are alleged in the petition. So you want to make sure that the petition is very thorough and covers all of the events that the respondent wants covered. When drafting, you have to make sure you're finding a balance between what the petitioner is comfortable with sharing with the court and what the court needs to make a decision. And that can be a hard thing to balance because a lot of these are traumatic events that survivors don't want to have to share over and over again. But using general language such as "he raped me," it may not be enough on its own to get an ex parte order. And so using more specific language about the event that happened will be useful in getting an ex parte order for a protection or harassment restraining order. And again, I already talked about this a little bit, but here at LADC, our standard procedure is that the attorneys don't draft these order for protection petitions. We have either the LAD or the 360 communities advocates draft them, or the parties draft them for themselves. And then once they've drafted and have a hearing, then we accept them on as a client and can help them once they have a hearing. So it's important to know, one, if you're talking to a survivor, where to send them to get help drafting a petition, and two, to really stress how important the petition is in the process of getting a civil restraining order. Some of the other civil remedies for survivors of sexual assault are custody and divorce. So if the victim and the perpetrator are married, the victim may want to get divorced, and they may not, but that decision is left up to the survivor, to the victim, of what option they want to take. And if the victim and perpetrator have a child together, but the parties are not married, they may need to go through a custody case to determine custody and parenting time with the child. Starting with custody and parenting time, for the law in Minnesota is for unmarried parents of children. Mom generally has sole legal and sole physical custody until the father files a petition for custody with the courts, which means that oftentimes I'm not suggesting to unmarried mothers to file for custody, but we're handling situations where fathers have filed for custody. And Minnesota does not, it's one of, I believe, 2 states that does not have a provision to terminate the rights of the father if the child is conceived by rape. What the state of Minnesota does instead is that they have 12 best interest factors to determine custody and parenting time. One of those 12 factors is whether or not domestic abuse has occurred as defined by statute. The domestic abuse statute includes criminal sexual misconduct within the meaning of the criminal statutes. And so it does become relevant in determining custody and parenting time. It's just not, there's not a way to terminate the rights if the child is conceived by rape. One of the other things to know is that parenting time in Minnesota, there's a presumption for each parent to start at 25% of the parenting time, which in a kind of regular schedule look is in every other weekend and 1 weeknight. And this is one of those areas where I talked about one of the limitations being the constraints of the law. Not a lot, but sometimes it can be hard for a survivor to hear that their perpetrator is likely going to get 25% of the time with their child. There are ways to overcome that 25% presumption, but what I've seen in most cases is they overcome it for a while and do a graduated parenting time schedule to get the other party up to 25%. And so part of being the victim-centered workplace that we are is we talk to them and we hear, what are your concerns about parenting time? What are your safety concerns? What are your concerns for yourself in exchanges? And what are your concerns for your children? And finding ways to work with our clients to fill those gaps and find ways to help them feel safer, knowing that their perpetrator is going to have to see their children. And that can be a really hard thing to do. And again, one of the limitations that I see in the work. The other thing is dissolution of marriage. So Minnesota is a no-fault state for divorces, which means that for sexual violence doesn't impact property division in Minnesota. The law on property division is an equitable division of assets and liabilities. Equitable doesn't always mean equal, but it means that whatever either the parties determine to be equitable or whatever the court determines to be equitable. So if you have one really high earner and one really low earner, one of the parties may get more assets out of the divorce and the other one getting more of the debt, just kind of determining what the parties are going to need to move them forward. But again, that sexual violence isn't taken into consideration for the equitability. If there are children involved in a divorce, then again, the same best interest factors and the same parenting time concerns that I talked about on the previous slide do come into play for that as well. And so it's a lot of those same concerns that I talked about on the last slide. All right, and that was it. Does anyone have any questions for me or anything else?
Also, the chat box is available if anyone would like to write a question there as well. I have a question that I maybe should already know the answer to, but are the orders for protection in HRO, are they just being filed online right now, or can we file them in person now too?
So my understanding is that the courthouses have little either drop boxes or mailboxes in front of them. And so petitioners can drop their petitions in those boxes or they can be filed online.
Yeah, okay. That's what I thought. I just wanted to double check.
Yeah. All right, I'm not seeing any questions, so.
Yeah, we can go ahead and wrap up. Thank you so much, Alina, for presenting. And we at 360 Communities really appreciate our partnership with you guys and all of the work that you do. We're just really thankful for all of those attorneys who volunteer and work with our victim survivors. So thanks so much, and thanks for presenting today. Thanks everyone for coming, and we'll see you at the next presentation next week.
Thank you.
Thank you.